Thank you for inviting me to speak to the Organisation for Defending Victims of Violence. I'm going to just talk briefly about the importance of the law of armed conflict to mitigate and limit the effects of armed conflict, because this is a pressing concern today. And we are currently witnessing some of the most brutal conflicts in human history. And it seems like law is powerless to stop perpetrators of atrocities. Now, international humanitarian law, or IHL, represents one of the most ambitious and paradoxical projects of international law. It's the attempt to regulate violence in its most extreme form. War has long been understood as a space of necessity, a domain in which strategic imperatives and existential threat can eclipse ordinary legal and moral constraints. And against this counterintuitive project, IHL asserts that even in the midst of armed conflict, legal norms not only persist but must be upheld. And IHL is important because it's designed to protect individuals during armed conflict, but it does so by balancing needs. It functions not merely as a body of constraints, but as a constitutive framework that defines lawful violence, structuring the conditions under which force is used and justified. And its core principles, distinction, proportionality, and proportions in attack, are doctrinally central, but they face increasing strain in contemporary conflicts, characterised by urban warfare, asymmetrical arrangements, technological transformation in the battlefield. And accountability mechanisms, though uneven in practice, play a crucial role in enforcing the normative authority of international humanitarian law by linking violations with individual responsibility. And increasingly, civil society organisations such as your own play an important role. So understanding IHL requires moving beyond a narrow doctrinal account towards a broader appreciation of how law operates in practice and how individuals can affect law. Because at its core, IHL is structured around a tension between military necessity and humanity. Military necessity allows for the use of force required to achieve legitimate military objectives, but humanity imposes limits aimed at reducing suffering and protecting those not participating in hostilities. The fundamental principles of international humanitarian law are centred around a couple of key notions. First, the principle of distinction and the protection of civilians. It lies at the heart of IHL. It requires parties to an armed conflict to distinguish between civilians and combatants, and to direct attacks only against legitimate military objectives. And its normative force derives from that simple but powerful proposition that civilians, those persons not taking direct part in the hostilities, must not be targeted in war. However, despite its doctrinal clarity, the application of distinction into contemporary conflicts is far from straightforward. And even where distinction is formally observed, the proximity of civilians to military objectives increases the likelihood of incidental civilian harm, and we've seen this most recently in its tragic iteration in Gaza. Turning now to the principle of proportionality, again, a fundamental principle of IHL that regulates the extent of harm that may lawfully result from military operations. It prohibits attacks expected to cause incidental civilian damage that would be excessive in relation to the anticipated military advantage. Now, unlike distinction, proportionality is not a categorical prohibition. It acknowledges that civilian harm may occur, but it seeks to ensure that such harm is not disproportionate. In this way, it functions as a mechanism for balancing humanitarian concerns with operational necessities. And connected to the principle of proportionality is the obligation to take precautions in attacking defence, which introduces a distinct dimension to IHL, a focus on the processes through which military decisions are made. Parties to a conflict are required to take all feasible measures to verify targets, minimise harm, and protect civilians. And these precautionary obligations are essential to the protective function of IHL. They emphasise the need for active measures to minimise harm and reinforce the integration of humanitarian considerations into military decision-making. But all of these rules are only as good as the forces applying them. So there has to be carefulness and caution by those who engage in those attacks. And unfortunately, what we're seeing lately is a real willful ignorance of the rules, or a willful rejection of the rules. That being said, there have been significant strides in the field of enforcement of international humanitarian law, which unfortunately means that we are looking ex post facto rather than preemptively. Ideally, we would be in a world where we would never need to follow up with individual criminal accountability or state responsibility because all of the states were following the rules. But as we've seen with the bombing of the school in Iran at the beginning of the war between the US and Iran, and the attacks against Iran by the US, we are seeing parties to a conflict not following the rules. So accountability has become a central pillar of the contemporary IHL framework. It's transformed norms into enforceable standards, linking violations with consequences and reinforcing the authority of the law. But enforcement remains uneven and constrained by political realities. The development of international criminal law has fundamentally reshaped the language of IHL and the landscape of IHL. It's expanded the scope of responsibility, it's clarified legal principles, and it's strengthened the normative force of humanitarian rules. But it depends on the degree to which states parties decide to buy into the international criminal law framework. We are seeing movement domestically where states are beginning to enforce IHL against their own citizens. We see this in Australia, in the UK, in Europe, where our own personnel are being held accountable, but we are not seeing this widely enough because international humanitarian law occupies a complex and often contested position within law and within armed conflict more generally, because it seeks to balance two seemingly opposed ideas: military necessity with humanitarian protection, constraining violence while allowing certain forms of it to remain lawful. And while its core principles continue to shape the conduct of hostilities, even as their application becomes increasingly difficult, we have to look to other ways beyond just that of states in order to ensure that the accountability mechanisms reinforce the normative force of the law by linking violations to consequences. In that respect, the future of IHL is likely to involve a pluralistic framework, drawing on international enforcement mechanisms, but also drawing on domestic and hybrid mechanisms, and having an increased role for civil society organisations to hold their own states and other states accountable for their breaches of international law. There is an increasing emphasis on strengthening domestic capacity, on improving international cooperation, on developing new tools for evidence collection and preservation through interviewing victims, interviewing and collecting evidence on the site. And certainly civil society organisations have an increasing role to play there. And emerging forms of warfare presenting new challenges, but also new opportunities for accountability with civil society organisations. It's been civil society organisations that have been increasingly involved campaigns to try and limit things like nuclear weapons, cyber operations, autonomous systems, to hold states accountable for their breaches of international law and their compliance with international law. And so these challenges highlight the need for continued evolution in the mechanisms of accountability, for increased involvement of states and non-state actors, including civil society organisations, in mechanisms of accountability, ensuring that the law remains capable of addressing new forms of conflict while preserving the core principles of IHL. Because accountability mechanisms, as I said, reinforce the normative force of law and make it something that has real bite. As I mentioned at the beginning of these notes, IHL sits at a complex intersection. It doesn't eliminate war or suffering. It authorises or sanctions or immunises certain kinds of violence. But it retains its significance even 160 years after its first modern iteration in the Geneva Convention of 1864. Its significance lies in its ability to define the boundaries of acceptable conduct and to preserve a measure of humanity within conflict. Because in a world where armed violence persists, this remains an essential legal and moral function. Thank you for your commitment to the rule of law.